You're the last case to come before us today, and Mozingo versus 2007 Gaslight, Ohio. Each side will have 15 minutes, and again, I emphasize side, so multiple athletes have to split their time. So, you ready to proceed? Oh, I'm sorry.
I'm the App.No here.
Oh,
But I am ready to proceed.
I saw the two athletes, so I got confused. So, all right, gentlemen, are you ready to proceed?
Yes, Your Honor.
You may proceed, you have 15 minutes, and you may reserve up to 5.
Your Honor, we're going to split our time 6.5 minutes each and reserve 2 minutes for rebuttal.
Okay.
May it please the Court, my name is Brian Zimmerman, and I represent 2007 Gaslight. The two issues that I intend to address that require reversal of the trial court's order are the fact that the trial court ruled and made a determination on the merits of the case, and secondly, the issue of predominance. With respect to the first issue, as this court's well aware, this court reversed the trial court once before. It was remanded, and the posture of this case hasn't changed. There was no additional evidence that was offered before the trial court. Appellee merely amended his motion for class certification, and the trial court merely revised her order granting class certification. If Your Honors would look at paragraph 9 of your prior opinion, this court quoted several paragraphs from the trial court's order and italicized those paragraphs. The paragraphs that were italicized, the points that this court made to reach your decision that the trial court rendered made a determination on the merits. Part of the language was the defendants do not dispute markup fees were not disclosed by either the Willegas or Gaslight. Second italicized portion by this court in its order on page 5. The court italicized that each of these class members was undisputably charged a markup to their gas fees without disclosure as required by statute. And the final point that was italicized to reach your opinion the first time was that quote, it appears to this court that the collection of gas fees was improper. And based on the language in the trial court's order, this court properly found that the trial court made a decision on the merits of the case. The trial court's order in this context is really no different than the last order. And we've excerpted out in our brief on page 13 4 different bullet points that are basically the same thing that the trial court did before. First bullet point, the court states in her order, the trial court states in her order that all current and former residents at the specific location of the Gaslight Village Mobile Home Park were subjected to the undisclosed markup and paid for or were charged for the surcharge gas usage after the park initiated the sub-metering system. That's on page 5 of the trial court's order. Second point that we bulleted out is from the trial court's order from March 2001, and it goes on, the trial court said that the defendants invoiced tenants for gas usage which included an undisclosed markup fee. To quote the trial court, a separate statutory violation occurred which constituted a new breach of contract. That's on page 6 of the trial court's order. Pages 9 through 10, trial court found that each plaintiff and each class member suffered the same injury by the park, and the relief sought is the same for plaintiff as it is for the other class members. And then the last bullet point, the trial court found, I'll quote the trial court, the same concealment and overcharging of utility fees in violation of Ohio law. Trial court found as it relates to these defendants. This is no different than what this court found in your prior opinion. Trial court threw in some allegedlys in this new order, but if you look at the substance over form, it's clear that the trial court abused her discretion or made a mistake in the law by making a finding on the merits. This court made it very clear in your prior decision on page 6 that a preliminary determination of the merits may result in substantial prejudice to a defendant. The court's tentative findings made in the absence of established safeguards may color the subsequent proceedings and place an unfair burden on the defendant. And the very purpose of this standard is to avoid a trial court ruling on the merits, so you don't get into a situation where the tail is wagging the dog. And that's exactly what this trial court did. With respect to our first point, we believe that the trial court either abused her discretion or made a mistake in the law by, again, making a determination on the merits of the case. This court cited Hill versus Moneytree. It's on page 5 of your prior decision, which says that the court reaching an opinion on the merits is improper and an abuse of the discretion. The second point that I'd like to speak to is we believe the trial court abused its discretion in terms of whether or not common questions of law and fact predominate. Mozingo, in his responsive brief, argues that the burden of proof is on the defendants when it comes to class certification, but that's incorrect. In your prior order, this court pointed out clearly that the burden of proof is on the plaintiff and that it's up to the trial court to conduct a rigorous analysis of all the factors that are set forth in 23B. In our briefing, in our brief that's before this court, it's our position, and I believe it's very clear, that the trial court certified an overly broad class. The trial court's class includes all residents of the park that received invoices associated with gas usage, whether they paid for the gas usage or not. So the class that the trial court certified would include members, because of the overbreadth of it, would include members who weren't actually injured because they didn't pay for the gas. It would include transitory members, those who didn't pay or stayed only for a brief period of time, so the injury is not the same as the rest of the class. And it would also include those who were evicted but still owe money, and those who owe money to Gaslight under a payment plan. The trial court and the plaintiff, appellee in this case, harped on the fact that liability should be determined as a matter of law, but again, that's getting into the merits. And our position is that even if liability is determined, an individual inquiry into whether each tenant paid rent and gas charges would need to be conducted. The trial court failed to recognize individual issues for each member. We cite in our brief papers several cases that support our position. The first case that we cite is the Petty versus Walmart case. This is a wage and hour case where the plaintiffs in that case sought certification and argued that the class was forced to work off the clock. The Court of Appeals found that damages were not susceptible to class-wide proof because the damages would be highly individualized, because each person that worked off the clock were working off the clock under different circumstances. In this case, the plaintiffs, the appellees, asserting the same argument that was asserted in the Petty case, and that is that the trial court could weed out people who shouldn't be part of the class, people who were not injured. In the Petty versus Walmart case, said that's not permissible. If permitted, the plaintiff could define, and to quote the Petty case, if permitted, the plaintiff could define the class broadly in hopes of netting certain percentages of injured members, which is inappropriate. The Best Buy case is also instructive in this context. In that case, the appellate court found that the class was overbroad, because it included all account holders who were assessed finance charges, whether they paid them or not. Simply, if they were assessed the charges, that they were included in the class. And the appellate court found that was improper because it included members who weren't injured. Similar to this case, the class that was certified included those who may have been charged but who didn't pay for the gas. The appellate court in the Best Buy case determined that a person injured would be the subset of the class rather than the class itself, which the court found to be improper. The Roto-Rooter case is the last case that I'll discuss with the court, which also, I believe, is instructive in this context. In that case, customers were allegedly charged a miscellaneous supply charge. And in that case, the court focused on the damage element and whether the plaintiffs were damaged in the same way or in a different manner. And the court found that some customers used more and some used less of the services that were provided by Roto-Rooter. And the appellate court found that there was no evidence of a class-wide injury similar to this case. This case would require many trials to determine who paid for the gas, how much each person paid for the gas, whether people were actually injured that were part of this class that was certified. And there's no evidence that's before this record. In fact, I believe the evidence shows the opposite, but there's no evidence that's in the record that was proffered by the plaintiff that all the class members have suffered the harm to which common questions of law or fact apply.
Counsel, I'm going to interrupt you because
Yes, Your Honor.
I'm not sure how much time you want to reserve to the other appellant, but you only be down to about 5.5 minutes.
I will reserve the
You
remainder.
can do whatever you want to.
I promised that we'd split it up. Thank you, Your Honor.
Thank you.
Thank you, Your Honor. May it please the court, my name is Attorney Scott Flynn. I represent George and Patricia Wallaga. Mr. Zimmerman and I are kind of on the same side, but we have different issues as well because my clients haven't owned the park in a number of years. So while I support Mr. Zimmerman on, and in fact, assignments 1 and 4 of my brief touched upon the two issues that Mr. Zimmerman just talked about. So I'm going to focus on my second and third assignments of error. First one being standing. This court has already, in its first decision in 2012, said that Mr. Mozingo needs to show that he has standing and he's a member of the class that he seeks to certify. Ironically, exactly 15 years ago to this date, my client on March 15, 2001 sent notices to all the park tenants implementing this change, stating that on May 1st, 2001, this sub-metering was to go into effect. Mr. Mozingo wasn't even a tenant at the time. He didn't move in until 2002. Somehow our trial court said, quote, the tenants were subject to the same notices as Mr. Mozingo. That's impossible. Mr. Mozingo wasn't even a tenant when the changes were implemented. And so took a couple paragraphs from the plaintiff's complaint. They say these are allegations the defendants made in 2010, or excuse me, the plaintiff made in 2010, stating defendants did not specify the date of implementing this new park rule in a written notice delivered to all residents at least 30 days in advance of the change. That's not true. Defendants did not disclose the amount they would charge residents, the purpose of the charges, or the basis of how the charges would be calculated in a written notice delivered to all residents at least 30 days in advance of the change. That's not true. Either that's not relevant for today, but the fact is that is relevant is the plaintiff wasn't even a member or a tenant at the park at that time. So how he can make allegations about what notices were sent to the tenants when he wasn't even a member of the or a tenant of the park is mind-boggling. There are other allegations in the complaint where he talks about my client not providing written notice prior to the tenant signing a written lease agreement. Mr. Mozingo didn't even sign a lease agreement, has never signed a lease agreement. There are a lot of things that Mr. Mozingo is trying to carve his class to include himself, but he doesn't have standing in this matter. Many of the allegations of the plaintiff's complaint are irrelevant to Mr. Mozingo's time at the park. And so the other issue is that this court identified at the last appeal was that the plaintiff needs to show that he's the class is identifiable and unambiguous. They must provide a means to identify the class. And what we had the trial court do was just parrot the brief of the plaintiff in saying that, well, the Wallagas, quote, will have the names of the former tenants in the records. That's a big assumption to make. 6 years into litigation, they're just speaking as if my clients will have certain records. They haven't owned the park in over 8 years. Plaintiff states they're subpoenaing records from third-party vendors. They said that back in 2011. 2013, they refile and say, we're still subpoenaing records from third-party vendors. Where's the evidence? Where are the means? Where's the evidence? Where are the records that show that these third-party vendors have the actual information to identify the class? We've not seen that in 6 years. And frankly, the tenants aren't in privity with the gas company or the water company anyway. They wouldn't have the records even if he did have asked for the records. And more importantly, for my purposes, the only records he subpoenaed were for a period of time from 2008 to 2011. My clients weren't even the owners of the park in 2008, 2011. How can subpoenaing records from a third-party vendor provide the means? And the trial court just took that for its word, as if these records were readily available. We're going to hire a computer expert. That's their rigorous analysis. That's how we're going to find these people. I mean, this is a transient group of people, obviously the tenants. I've done their evictions for 8 years since my clients owned the park. I did an eviction in Stowe Muni Court last week. These people could move in and out of the park all the time. Abandoned mobile home titles, I file for them all the time for this park. And just to say I'm going to hire a computer expert to do a reasonable internet search and find these people, when the plaintiff himself admitted he's never reached out to any of the other tenants of the park to discuss this case. They're just moving out left and right or being evicted left and right. There isn't a database of mobile home park tenants for this. So the court needs to make sure that they have the means to identify these, rather than just take the plaintiff's word that he can someday find these tenants 15 years after my clients provided the notice to the tenants. So those two issues are more related to my client's, actual tenancy at the park. We have statute of limitations issues. We have the trial court, for some reason, interpreting the statute already, stating that my client, violated the statute, even though there's been no evidence of that, or but between that and the unwieldy nature of a case, which the trial court seems to imply it would be kind of a mess, but saying, yeah, we're still going to do it anyway. We're going to make this a class action. We've got different park rules when my client owned the park versus when Mr. Zimmerman's client owned the park. We have different leases. We have oral leases. We have written leases. Every lease is personal between everybody. I mean, your written lease may say something different than somebody else's oral lease. We got different gas charges, different payments, different amounts of gas being used. All of these things.
Counsel, your time is expired.
Thank you.
Thank you, Your Honors. Police Court, my name is Tom Connick. I'm here on behalf of Mr. Mozingo and the putative class. I guess let me just start backwards. A lot of what Mr. Flynn was just arguing with you today, right before he sat down, has absolutely nothing to do with class certification under Ohio law or under federal law for that matter. And Ohio law takes a lot of its direction from federal law. Much of what Mr. Flynn was discussing, number one, isn't even in the record because they were arguments of counsel. Regarding the damages, Ohio law, and again, federal law, which Ohio law takes a lot of its direction from, is extremely clear on the issue of damages in class actions. Disparate damages, if they do in fact exist, does not defeat class certification. It's insufficient, and that's in both Ohio Supreme Court case law and a plethora of federal court case law that says the same thing. Now, kind of going back to the beginning here, the main issue that was before this honorable court, I think, in Mozingo 1, as I will term it, which both Mr. Zimmerman and Mr. Flynn argue here again, is that the trial court did not engage in rigorous analysis and engaged too far into determining the merits of the case. This was extensively briefed in Mozingo 1 and Mozingo 2, but the main difference, and it's a critical difference for this honorable court, to realize is after Mozingo 1, the United States Supreme Court and the Ohio State Supreme Court both acknowledged and affirmed a longstanding rule that you have to look behind the pleadings and you have to engage in some analysis of the merits of the case to determine that all elements of Rule 23 are met for class certification. The Stamco case, which is, I don't even think mentioned, or at least mentioned only in passing in the briefs from the appellants in this case, followed the United States Supreme Court rule and indicated that there will be, not that there might be, but there will be a necessity for engaging in some type of analysis of the merits of the case, as long as the trial court does not commit, quote unquote, a free-ranging analysis into the merits of the case. And the trial court in this case clearly did not engage in what could be termed a free-ranging analysis of the merits of the case. I think the trial court in this case went to great lengths, went to great pains to correct the criticisms that this honorable court indicated existed in Mozingo 1, and the trial court went point by point and cured those deficiencies or criticisms in what can only be labeled an extra rigorous analysis into this case and into the elements required for Rule 23. And this is an abuse of discretion standard. The trial court has twice now gone over this case. We understand that it was reversed the first time and sent back. We didn't necessarily agree with that. But not only did the case law change based on what the early criticisms of this honorable court had for the trial court, but the trial court went back and went to great lengths to answer the questions that this honorable court had. And the trial court did so. Mr. Flynn and Mr. Zimmerman point out to certain points in the trial court's order where the trial court added a word allegedly or this or that. I don't know what the trial court is supposed to do otherwise to point out that the trial court engaged in a rigorous analysis. I mean, the fact of the matter is the trial court in determining Rule 23 is allowed to take the allegations set forth in the complaint as true. The record below is clear that the defendants admitted that there was an undisclosed fee. They admitted that there was no notice. These are facts that are self-evident in the record. So it's hard not to recognize those. And this is a strict liability statute. The statute in which this case was brought is very strong in Ohio law to protect the mobile home residents in the state of Ohio because there is such rampant fraud going on in that area. And when you have defendants who admit that they violated a strict liability statute, I don't think that is going behind and digging in too deep into the merits of the case. It is self-evident. And I think it would probably be error for the trial court not to at least recognize that. And the trial court did recognize that for the purpose, and this is critical, for the purpose of analyzing the elements of Rule 23. And the issues that Mr. Flynn, again, and Mr. Zimmerman speak of today don't go to those issues. They don't go to the issues of whether or not Rule 23 was complied with for purposes of class certification. The arguments that you heard before I stood up here go to the issues, in fact, of the merits of the case and whether or not damages should be awarded. These things are left to be decided after class certification is awarded. Class certification is a very, it's a tool for combining all these claims. It's not a tool for resolving damages issues or anything like that. Also, as to Mr. Flynn's argument that, all these tenants might not be around, we can't find them, this, that, and the other. This court has already determined in Mozingo 1 that Mr. Mozingo has both an interest in this claim, i.e. standing, and also his claims are common with everybody else. Now, the case law, again in Ohio, and in federal law is very clear. A finding of commonality almost always will follow with a finding of predominance. They're two interrelated concepts. They're two interrelated elements of Rule 23, and it is extremely uncommon to find that common issues of law and fact exist to comply with Rule 23, and then to find that the issue of predominance is lacking because they are so intertwined. And the fact that this honorable court has already found commonality is the law of the case. And when this honorable court asked the trial court to revisit some of the issues like predominance, the trial court did so in a rigorous analysis. And that is the analysis that this honorable court has to look at. Did the trial court do its duty? Did the trial court conduct a rigorous analysis? And I don't know what else the trial court could have done to do a more rigorous analysis than what it did. Mr. Zimmerman, I think it was Mr. Zimmerman who mentioned that it was our argument that the burden of proof is on the appellants regarding predominance. That's not the case. I don't think I ever argued that. I don't think I ever would argue that because I know that's not to be the case. So I just wanted to clear that up.
I think what was stated was the trial court wrongly allocated. Not necessarily that you had argued, but the appellant had argued it, but that the trial court in its entry had wrongly allocated the burden to the plaintiffs.
I'm not aware of that. I mean, I'm just answering what Mr. Zimmerman said today before you. I mean, I've never argued that. I would never argue that. And that's not the case. Also, this notice letter. I mean, the issue here, the sole issue in this case, is that there was improper notice about undisclosed fees. That applies to everybody across the board. Every single person who, within the class period as defined in the class definition, is subject to that same generalized proof, that same common question of fact. And by the way, common question of facts, you know, when we file class actions, we list, you know, I don't know, 1, 2, 5, 10, 18 potential common issues of fact and law. You only need one under Rule 23. You only need one to meet that element. You only need one to meet predominance that follows almost always commonality. And in this case, this case comes down to really one issue. Were these tenants subject to lack of notice of an undisclosed fee? And in the record, the defendants have admitted to both. So if this honorable court, and this case, by the way, is the preeminent type of case, the typical, the case study of a class action case. We have individuals who are unfortunately of modest means, living in a mobile home park, who are getting defrauded and who have been defrauded and have no recourse at all, none. And we have a defendant who's admitted that they defrauded them. They admit that there was an undisclosed fee. They admit that there was no proper notice. Matter of fact, the undisclosed fee, the testimony was, it was upwards of 50%. So this applies to everyone. This is what a class action is for. That one common question of issue and fact applies to everyone. And the backdrop of that fraud, that breach, is a strict liability statute that the General Assembly of this state specifically designed to protect these people of modest means.
Of what import in the class certification procedure would be, if indeed it happened, an admission by the defendants that they charged a fee that was not disclosed?
As far as the class certification goes? Well, as far as the class certification goes, that would be, and again, number one, we allege that in our complaint, and the court has to take that as true. That would just be an affirmation of the allegations that we have in the complaint. But I don't think, as far as Rule 23 goes, I don't think it's necessarily, well, matter of fact, I know it's not required to establish a class certification under Rule 33. I mean, a defendant doesn't have to admit liability in order for class certification to be determined. It just so happens in this case they did. And I think the court, the trial court, is well within its duty to acknowledge that. I mean, the trial court did not base her decision or base its decision on that admission, but it was acknowledged. And that's part of the rigorous analysis. I mean, look at it the other way. If the trial court did not acknowledge that issue and decided to deny class certification based solely on that issue, I think that would be error. Because it's an acknowledgement, and it's something that's in my pleadings. Anyways, she would have to, the trial court would have to take that as true anyways for purposes of class certification. So, looking at it another way, based on their argument, the trial court looked behind the pleadings too much and engaged too much in determining the merits of the case. I think that's an illusory argument because it's already in my pleadings, and the trial court is obligated to take it as true. The trial court didn't do anything more in acknowledging that fact than acknowledging my pleadings, which the trial court is obligated to do. So, and I go back again, the trial court did not base the granting of class certification on that single issue at all. I think the trial court in Mozingo 2, the opinion, went out of its way to address the issues that this honorable court had, and went out of its way not to rely solely on anything regarding the merits of the case. But again, I stress, and I go back to this, and I began with this, Your Honors, both Ohio law and federal law, they not only acknowledge, but they state it will be required almost always for a judge to engage in an analysis of the merits of the case to determine that the Rule 23 elements have been met. The trial courts, or the judges who assess and analyze the elements of Rule 23 for class certification, just cannot commit in what the Ohio Supreme Court has termed in Stamco a quote-unquote free-ranging analysis of the merits of the underlying case. The trial court cannot be said in this case to have committed a free-ranging assessment or analysis of the merits of the court. Not only that, and I pointed this out in my brief, the appellants don't provide any evidence, very little argument other than conclusory argument, that there was a quote-unquote free-ranging analysis of the merits of the underlying case, because it doesn't exist. It just does not exist. So I'll just close with this case has been up and back a couple of times, which is great, but the significance of that is the trial court has now looked at this matter very deeply twice. And the second time has done so specifically to address...
You mean looked at it twice, I mean once originally and then once
right.
We sent it back.
Correct.
So,
Correct.
I mean, yes.
So looked at the issues
It's not
twice.
3 times now. Or...
No, looked at the issues twice. And the second time specifically related to the concerns this honorable court had that the trial court readdressed to make sure that that rigorous analysis obligation was met. I believe the trial court did meet that obligation. If this case were to be decertified by this honorable court, I believe that these individuals who live in mobile home residences across the state of Ohio will be harmed because they'll have no redress. This is a strict liability statute.
And you're out of time.
Thank you, Your Honor.
Thank you to both sides, the appellants and the appellee, as to arguments here to the court today. The court will take the matter under advisement and issue a written opinion. That will be sent to both sides, as well as it will be released on our website and Supreme Court website. Thank you.
Thank you.
Thank you, Your Honor.
Have a good day.